Joining me now to look at this developing story is Ireoluwa Oguntuase, a labor law expert. Thank you very much for giving us your time. What do you make of the order of interim injunction restraining members of the organized labor from proceeding with the strike they plan to commence on November 14?
Okay, so if we look at the order, I think the order is actually appropriate, going by the fact that the National Industrial Court is the court vested, with the exclusive jurisdiction of dealing with matters of this nature. By virtue of the National Industrial Court Act, particularly Section 7 of the National Industrial Court Act, which is in pari material with Section 254, Section 254C, subsection 1C of the Third Alteration Act of the 1999 Constitution as amended, we'll see that the National Industrial Court is vested, with powers to make orders of this nature. But again, the angle that we should also look at it is that should it actually snowball? Should we allow issues to snowball to this particular level, before we now go to court, before we turn National Industrial Court at every situation as a court of last resort? Before matters can get to this level, there is always an opportunity for collective bargaining. There's always an opportunity for collective agreement. So what happens to the process of conciliation? What happens to the process of mediation? What happens to the process of negotiation? All these processes have been laid down in the Trade Dispute Act for warring parties to actually explore, before thinking of proceeding to court. So I think that at every point in time, National Industrial Court and the government, they actually need to look at the procedure. They need to properly explore the procedure that is being laid down by the law before the National Industrial Court can think of, proceeding on strike. People should not be saying the fact that strike is the last resort. And if we look at the trajectory, the history, we usually see that the issue of going on strike by the Nigerian Labour Congress, people are now saying it as a sort of a statement that they will just utter without not complying with it. So it's not really making its effect again. So I think that at this juncture, parties should start exploring alternative ways to going on strike, because strike has never been the best way to resolve trade disputes.
To your knowledge, has there been any efforts by either parties to resolve this matter without needing to go to the courts before we come back to the court matters?
Well, to my knowledge, I believe that, because that's even the procedure that is being laid down in the Trade Dispute Act, particularly if we look at Section 3 and Section 4 of the Act, even Section 5 is very clear as to, procedures that needs to be followed.
No, before, I'm asking in respect of this particular
or trade union organization.
Ireoluwa, I'm trying to find out from you if you know of any current conversation as regards this particular issue that's taking them to court. Do you have any idea whether a conversation is ongoing or both are hell-bent on doing what they plan?
Well, I don't have any idea whether a conversation is ongoing, but again, if we look at the trajectory, we would always see that there would have been a conversation, and at a particular point in time, there would have been breakdown in that conversation before parties now decide to, before the Nigerian Labour Congress now decided to take up, the gauntlet and now decide to go on strike. So for me, my personal opinion, I'm not aware of any conversation, but I'm trying to draw inferences from the past issues that have ensued.
All right, quickly, before we let you go, the justice said the order shall subsist until the determination of a motion or notice for interlocutory injunctions equally filed by the AGF. Do you think Labour should wait for the determination of the notice or challenge it in another court of law?
Well, you know that as far as law is concerned, all these things have specified procedure. Now, the court has given an order, and the order that the court gave is an order of interim injunction, and the court has the jurisdiction to give such order if we look at Section 19 of the National Industrial Court Act. So I would think that because if we look at Section 6 of the 1999 Constitution, the court is vested with the jurisdiction of adjudicating between the parties. So National Industrial Court should wait it out, because the Nigerian Labour Congress rather should wait it out and explore this procedure, because by the law, the National Industrial Court is the court vested with the exclusive jurisdiction of determining issues of this particular nature, particularly on Trade Dispute Act. So the National Industrial Court, I don't see them going to another court.
All right. What would be, if any, consequences for disregarding the judgment? Would there be any consequences?
Of course, if National Industrial Court, if Nigerian Labour Congress disregard the judgment, that's a pure contempt of court and is a criminal offense. And I don't think officers of the Nigerian Labour Congress are immune, from all this if they decide to disregard. And I also think that it is even appropriate, because the Nigerian Labour Congress are a body created by law. And to that extent, they are bound by the decision of the court, their juristic personality. So to the extent in which their juristic personality, they shouldn't go against the order of the court. That's contempt ex parte. So I don't see them going against the order of the court. And if they go against the order of the court, that is contempt of the court. And we all know the implication. That's a criminal offense. And they can go to prison as a result of that.
Thank you very much, Ireoluwa, for giving us your time. We appreciate some of the insights you've provided.